Good morning. It's a beautiful day right here in the city of Abakaliki in Ebonyi State. My name is Amaka Izujuku. Right here in the studio with me, I have this very lovely grandma-to-be. Laura, it's so nice to see you.
Yeah.
I'm beginning to wonder which of them suits your skin tone more. Is it the purple? Is it the milk color? Is it the other colors I've seen you in? You look dashing, really.
Thank you, Amaka. You're not looking bad yourself. I mean, your orange is actually oranging. You look beautiful. The combo is just wonderful. And how was your weekend?
Well, let's not just talk about the weekend now, because all you get to hear is I did this, I did this, I did this, I did this. And in all of this, you wouldn't hear, so I took some time and rested. So let's not talk about the weekend.
Oh, I don't envy you. Well, I passed through that route, so it's your turn now. I'm done with all that. Enjoy.
All right, so we're going to be taking a quick break now, and when we return, you will be hearing from the Attorney General of the state. Let's see how far this ACJA that was adopted that was domesticated in Ebonyi State in the year 2019 has been implemented. And right after that, we'll bring you up to speed on what's happening within Ebonyi State, Nigeria, and elsewhere when we bring you the Salt Television news. We'll return to look at the newspapers and take a look at some of the trends happening within Nigeria and maybe elsewhere in the world. It's sunrise. Let's make your morning bright. Please stay. To enhance the efficiency of the legal system, the Criminal Justice Act, the administration of the Criminal Justice Act of 2015 was enacted. In the year 2019, Ebonyi State domesticated this act. So Ebonyi State can with its full chest say that there is the Aja Act in force in Ebonyi State. Well, I called it Aja Act because that was what my guest today told me it's called, and if you can say it's the Aja Act, so who am I, right? The Aja 2019 for Ebonyi State. And this was enacted and implemented just so that we can have a better justice system, a system where everyone says the justice system favors me, I am not disenfranchised, and yes, I have full confidence in the justice system in the state. Now, my guest today is not just the Honorable Attorney General and Commissioner for Justice in Ebonyi State. He was at the forefront of ensuring that Ebonyi State moved with others when this Criminal Administration of Criminal Justice Act made its way to Nigeria. He was in the struggle for its domestication in the state, and now today, who better else to implement it than his humble self? My guest is, you already know, the Honorable Attorney General of the Federation, you know, I'm prophesying, of Ebonyi State, and the Commissioner for Justice as well, Honorable Barrister Ben Uruchi Udo. Thank you so very much for joining us, sir.
Thank you for having me.
It's a pleasure to have you in the studio.
All right, so let's just get into it. I mean, you were there right through the days of let's domesticate this act for the state. It's going to do so well for us. Now that you are at the helm of affairs, that it's on your table to ensure that it's implemented, how far so far?
Thank you so much. I'm deeply humbled to be here. Well, the domestication of the Administration of Criminal Justice Act of 2015, which we did in 2019, is yielding fruit. Firstly, it has created a paradigm shift from the retributive justice system that we had to restorative justice system that we ought to have, that we long to have. So that paradigm shift is overtly manifesting. Now, the problem I had before I came on board, during the drafting of that law, now, that law made Attorney General to be the chairman of the Justice Sector Reform Team. as provided by Section 538 of that law. It's a very beautiful law, a law that has 45 chapters and 552 sections. Now, the problem we had before my appointment is the implementation of that law. The law has been partly implemented, but when I came in, I had to meet various major critical stakeholders. Because without this person, this law cannot be implemented. I met with the Chief Judge, I met with the Commissioner of Police, three of us. We had a meeting to say, this is what we need to implement this law. So all of us will be on the same page that enable us implement this law. And since I got the cooperation of the police, I got the cooperation of the Chief Judge, same page, and the implementation is ongoing. If you ask me to rate the implementation, I will rate it 70%. We want to get up to 100%. For example, the first thing I did as Attorney General was to look at Section 181 of that law that have now been implemented prior to my appointment. What did Section 181 provide for? It provides for laying off lay prosecutors from prosecuting. Before my appointment, people that have been prosecuting matters are policemen who are not lawyers, who have not been called to bar, but over time they have acquired skills in prosecution. Some of them, I give it to them, they prosecute more than lawyers, because some of them have been prosecuting for 20, 30 years. So they know the art of prosecution, know the art of advocacy more than lawyers. So when lawyers go to court to defend, you see policemen who have not even seen the four walls of the university defeating lawyers that have been called to bar, because over time they have acquired the skill. But the law says if you have not been called to bar, you cannot prosecute. And even the amended Police Act, the Police Act of 2020, Section 66 of the Police Act, provides that lay prosecutors cannot prosecute matters of police. And so we policemen who have not been called to bar cannot prosecute. They became angry, and it was more or less like an ambushment. They had to seize all the case files they had. They said, okay, if you say we cannot prosecute, we will not return the files we have. Or go. Sometimes when they even invite an IPO to come and testify, they want to frustrate you. That's why I had to have that tripartite meeting between the Ministry of Justice, the court, and the police to say which way out. What do we do? Okay, you have, and it's unfortunate because if you're a police officer and you have been called to bar, you can prosecute. So, and the whole of Ebonyi State Police Command, we have only six policemen who are lawyers. In the whole of Ebonyi State Police Command, only 6. Out of these 6, only 4 are in active practice. So, you can imagine only 4 prosecuting for. So, we had a meeting. Okay, I am not saying police do not prosecute, but those of them that have been called to bar, although every of the prosecution will have the fear out of the Attorney General. So, but with that understanding, so what you have to do with, because usually they prosecute in magistrate court, and I have 85 lawyers in the Ministry of Justice. Okay. So what did I do? I had to say, as I'm taking policemen from prosecuting for us, I did not want to create a lacuna. So we have 47 magisterial districts in Ebonyi State. We have 47 magistrate courts in Ebonyi State. I have to post 47 law officers to these magistrate courts who will be prosecuting as I'm laying off lay prosecutors. Okay. And it's been working since then, even though at the beginning we had a challenge, it's been working. Now, secondly, the major hiccups we have in the implementation is we didn't have the Administration of Criminal Justice Monitoring Committee, who will definitely monitor to see the implementation. I just appointed a monitoring committee waiting for their formal inauguration, because there are some sections that have not been implemented, and it's as if we are adamant. I'll give you examples, just for paucity of time, 3 of the sections, which we are intentional in implementing. Section 30 of the Administration of Criminal Justice Law provides that every quarterly, the Commissioner of Police or an officer that is in charge of a detention center must make a quarterly report on the number of arrests made attached with the register of arrest to the Attorney General. So I'm expected at the end of every quarter to be able to have a database of how many people were arrested with or without warrant that are in police custody. So I'll be able to know the status of those people that have been arrested. I have never received quarterly reports from the police commissioner or any officer in a detention center. Now, Section 34 have not been implemented. Section 34 provides for police officers reporting to supervising magistrates that every last day of every month, every last working day of every month, DPO of every divisional police must make a report to a chief magistrate in that jurisdiction to say these are the number of persons in police cells that have been arrested without warrants. So the chief magistrate or any magistrate designated for that purpose by the chief judge will be able to know that in police station, in the divisional police station in a Kaba, we have about 10 or 20 persons that are in cells have been arrested without warrant. So to enable the magistrate know, give an instruction and order on how for them to be arraigned. It has not been implemented, but because no police of chief magistrate have ever received such monthly report from the police. Lastly, in Section 35, Section 35 provides that every month, chief magistrate of a magisterial district must visit the police station to do what? Number one, to conduct an inspection on the register of arrest. 2, see the number of people that have been arrested with or without warrant. 3, order for their arraignment before a court of competent jurisdiction. And 5, if it is a matter that the chief magistrate has jurisdiction over, can grant them bail at the police station without arraigning them. I have not seen any chief magistrate that have visited any police station to order for a release of someone who have been illegally detained in police station. We had a meeting and said, look, this monitoring committee must move into action to see specifically that these essential 3 sections are implemented. So I want to assure you that it's ongoing.
You know, because these 3 sections you pointed out actually formed the crux of the reason why you are here today. Because the word on the streets is that police is your friend only on paper. When it comes to reality, they are not your friend. And it's good you've said that these particular sections of the Ajah Act have not been implemented in Ebonyi State, and you've had a meeting with the monitoring committee. It's the magistrates who are supposed to actually go on this routine visits to the police stations, and then the police stations would also report back to them. I want to know, where is this, I don't know if I should use lacuna, where is this gap coming from? Is it that the magistrates are not aware of this act and that it's something they should do? Or is it that the police, not the boss now, the people, the DPOs, the ones in charge of the stations, are not aware of this? If it is not a question of knowledge, why are they not doing it on both sides, not just on the side of the magistrates now, but also on the side of the police? Or is it a question of you should come to me, I'm not the one who is supposed to come to you?
You see, like Proverbs says, my for lack of knowledge. You know,
yeah, you did say so.
And then when I came on board, I discovered that this law is partly implemented. Even before I came on board, the percentage of implementation was 30%. So, but we are intentional about full implementation, and that's why, like I said, we've had this. Now, what we did 3 months ago was I had to write to the Office of the Attorney General of the Federation, who said the limitations were changed. We had a training, because you cannot give what you don't have. We had to do a training. We even invited the most senior magistrate in FCT who have been implementing these sections in the mother law. She came here, and then we had to train the magistrates, on how to go about this, and the major stakeholders. So we had a meeting, and the modality was done. So like I said, that was just 2 months ago. We are waiting by maybe from next month. Then we see what they are up to. Most of the DPOs do not even have this law. Sometimes they are talking to them, which of the laws we are talking about. So what we have done, especially again too, in plea bargaining, I give you an example. Sometimes they will arrest people. Section 367 of this law provides for plea bargaining and modality for plea bargaining.
We will get to plea bargaining.
So to avoid it being abused, because they will arrest you. For example, police will arrest you and say there is a provision on plea bargaining in the law. You stole 1 million. If you accept you stole that you are the one who stole this money, we could discuss with the prosecutors, and then we could discuss with the Ministry of Justice and the court, and to see how they can reduce your sentence. Now the person will voluntarily admit, oh, I stole this 1 million, but I have spent 800. I've spent 200,000. I'm ready to return 800,000. What will be my reward for returning it? If the law says send this person to prison for 3 years for not wasting the precious time of the court, for admitting without delay, we can make an arrangement. Okay, while you return the 800,000 naira, you go to prison for 1 month instead of 3 years. I don't know. So, but to avoid it being abused, in the implementation of that section 367, we have to now have to police. They will not apply because they will need the consent of Attorney General to do that plea again, and they will do it in such a way that it will be abused. So we say no. Let us have plea bargaining prosecutorial policies and guidelines that will guide police on how to do it. So we have to, every application they made, we have to pause it until we put in place that which. By God's grace today, we'll be unveiling the Ebonyi State plea bargaining prosecutorial policies and guidelines. So anybody who wants to plea bargain, in the implementation of that section 367 will be guided by that guideline. So these are like something that is delayed in implementation of some of the sections in that law.
All right, Honorable Commissioner, just before we continue with the plea bargain, because we're actually coming to that, okay. I just want to know the clear distinction between the Aja now that we had before you came in and what is happening now. What is is there any clear distinction or difference of what it used to be, I mean, in the administration of the justice, the criminal justice system, and what we are having now?
Yes, there is a clear distinction. And that's why I told you that this tripartite relationship that is in place is a good thing that happened. I am on the same page with the Chief Judge. I am on the same page with the Commissioner of Police. These two persons are cardinal in the implementation of AJA. Because Chief Judge can frustrate you. Whatever thing you do, you go to court, you come back, you see the same thing. The police commissioner can frustrate you. So if the three of us are not on the same page, we will not be able to do this thing. What did the Chief Judge do? That showed a clear distinction. Chief Judge decided he has, under that law, he has power to make what is called AJA rules. So he has drafted rules to guide the implementation of AJA. It is based on this. Now it's under that rule that is called Ebonyi State Administration of Criminal Justice Law, Rule 2023, okay, which was released last year. Now under this rule, if you look under 14, provide for how a plea bargain will be implemented. But it can't be implemented without my prosecutorial policy, which we will be unveiling today. So you can see Chief Judge have gone on his own to see the effective implementation, which was never in existence Okay, to say this is how, if you are coming under AJA, this is how this is the law this is the rule that will guide it. I give you an example. You know, lawyers are very smart, skilled, largest crafty when they have a bad case. Some lawyers, with due respect, I will have a bad case. Every day I will keep going to court to get adjournment date to frustrate the matter. They will mention it. I will say, my lord, my client is sick, cannot come today. And my lord, this will happen. Let me give adjournment. You see a matter that would have ended within 6 months. They've turning into 10 years. You know, now under this, the chief judge have made a rule under this AJA. If you take adjournment for more than 3 times, you will pay costs, punitive costs. As a lawyer, the cost will be awarded against you for necessary asking for adjournment. You know, so now lawyers now say that, oh look, I cannot ask for adjournment anyhow, because if I take adjournment for more than 3 times, there is punitive cost against you, and it is at the discretion of the court. The court can award you 500,000 naira for asking for adjournment to frustrate a matter. It was not in place, but now chief judge has made it to be part of our rule. So lawyers are now sitting up because they cannot. It's no longer business as usual. I give you another example.
Sorry, just before we go, because we'll keep taking the instances, and would run out of time. I just do hope that the punitive measures really is not just monetary. It's something that will put a dent on the lawyers, because monetary someone can pay, but that's not the issue now. Now I'm taking you back again to this sections 30, 34 and another 35. Where about the magistrates and the inspections.
Yes.
And you said you constituted a monitoring team.
Yes.
I am hoping this monitoring team would also have the power to actually train these people. But I'm interested in the people who make up the monitoring team. Are they just legal practitioners, or are there laymen now, not lay prosecutors, who are also in this monitoring team, to bring a lot of divergent views yet heading towards one direction?
Is comprehensive. I have not done the inauguration. Maybe I don't. Let me say, unfortunately, you are even in the monitoring team.
You cannot say it's unfortunate.
So now, because you are just, maybe I don't know whether they have not issued you your paper. So that's why, and why I say it's unfortunate is that you will be taken out of your workplace to go and see what is happening in courts and in prison and everything. Not enough stress without pay, because it's a court duty for voluntary for the state, so don't expect remuneration. So that's why I say it's unfortunate. Now, the monitoring committee is comprehensive. We have a representative of the chief judge, representative of the commissioner of police, we have a representative of the attorney general, we have a representative of the DSS, we have a representative of the university committee, CSOs, the media. So it's comprehensive. So they'll be able to, because anytime the messages are going there, we will cover it. Media will have access to see what these things are done. And once they go there, it's compulsory that the DPO must bring out the register of arrest for everybody to see. This is the number of people we have in a month, for example, police station. So we don't want to make it to be a hidden agenda. And like I said, I assure you, it's going to be very comprehensive. Now, once we have that, I am working towards having electronic data, electronic data of all the persons that have been arrested within this period. So you can be anywhere you are. The good thing about this is that you can be here, I can be here as anything. They say they arrested someone, they are not charging the person. You can click our data page and say, okay, this person has been arrested this day, I've been arrested last year, I've been arrested this year. He's becoming a recidivist. What do we do? You'll be able to know the number of persons that have been arrested, those that have been wrongly arrested, and those that have been rightly arrested. Again, under this law, we are intentional. If a policeman wrongly arrests someone or arrests someone in lieu of an actual suspect, I committed a crime, police is supposed to arrest me, I ran away and they arrested you because you are my sister, the police will now pay you compensation by forfeiting 1 month of the person's salary.
All right, let's just hold that thought there. That's a good place to take a break now. We are going to take a short break, and when we return, we will continue, because this is becoming more interesting, where police will have to forfeit 1 month's salary. I think I like that. Sir, we're glad to have you back, and we're still here in the studio talking on what Ebonyi is doing as it concerns the criminal justice system, and of course the plea bargain. A manner has been developed. All right. While that is going on, we are going to now allow the Honorable Commissioner for Justice to unveil this manual that has been developed for Ebonyi criminal justice system. Sir.
Thank you very much. This is the manual, and it's going to take effect from today. This manual is policy, prosecutorial policy on plea sentence bargain in Nigeria. Just as the name implies, I know everybody is not a lawyer. Plea bargain is negotiation in criminal matter. Once you have a criminal matter or you're a suspect, avoid wasting the precious time of the court, and you're convinced you have done this, you can negotiate, and then there will be a reduction maybe in punishment, or a reduction maybe in sentencing, or a reduction in anything. So in a nutshell, plea simply means, or plea bargain is a negotiation in criminal matter with the intention of a criminal accused person going into a negotiation, an agreement with the prosecutor who have accepted to plea over the matter, and the prosecutor who will now accept to drop some charges, and the court who will, let's say, as a reward for the remorsefulness of that person, reduce the sentence. The person will not be totally exonerated, but they will be reduced the sentence. So these are what we are doing, and that's why we have this manual. The essence of this manual is to avoid the process of plea bargaining being abused. And I'll give you an example as we conclude. In Lagos State, someone stole, and during plea bargaining and allocutus, the person was asked, "Are you guilty or not?" He didn't want to waste the precious time of the court. He said he was guilty of the offense of burglary, and then he now gave reason that he burgled into his uncle's apartment to be able to pay his school fees, and that he is sorry. He didn't waste the precious time of the court. He admitted he committed offense, and the court in sentencing, instead of sentencing him to 4 years in Kri prison, they sentenced him to University of Lagos to go and study psychology. So that's what plea bargain is all about, because he stole to pay his school fees. Okay, but he was now sentenced to that university, but on the condition that every morning he will go to prison to sign attendance register before going for his lecture. So it will not be like we are now rewarding wrongdoing.
Okay. All right, so thank you very much, Honorable Attorney General and Commissioner for Justice, Ebonyi State. Thank you so very much for coming. Now, just as a way of wrapping it up, if you were to comment on the Rivers State crisis in 60 seconds, I do not want to talk about all the different opinions out there. If you were to comment as a barrister right now and someone in the public service, what would be your comments in 60 seconds?
I am the chairman of the body of attorneys general of the Federation, and we represent 36 governors as attorney generals. Our principals have not commented on it, so we are waiting for them to comment first before we can, so that we will not implicate ourselves.
All right, so this is spoken as a politician.
All right. Sorry, Amaka, just before we wrap it up, I just want to say that I hope that when we call again, you answer, because there are so many things that we were not able to ask, especially as it has to do with plea bargain. This is an area that I'm actually very interested in. We have the charge bargain and the fact bargain and sentence bargain. So those are areas that we need to touch to educate the public on some of these new laws, because it is not something that Nigeria has been into in a very long time. In fact, it started from the EFCC Act. Yeah. So those are areas that we will need to have series so that we can educate Nigerians on what is plea bargain and how it's going to play out in Ebonyi State. On that same note, I want to say a very big thank you for being on the program today.
Yeah. Sunrise would return right after we bring you the news. Please stay.